Good morning, everyone. Thanks for joining us. This is our first planned giving workshop that we're doing. My name is Quinn Lentz. I'm the Events and Development Manager for Animal Care League. But this morning, you'll be hearing mostly from Ted Cusack from the law firm Cusack and Associates. Ted's going to be going over some of the ins and outs of wills versus trusts and presenting for about an hour. As Ted mentioned, you can submit a question anytime during the stream back on the cusack.com landing page. Yep, and I think Tim's going to pull it up here and show you one more time. And Ted's going to answer those at the end of the stream, so make sure you go ahead and stick around and stay on. That's really all I have to say to introduce. I want to make sure Ted can get going. I know he's got a lot of information to share. So Ted, I'm just going to throw it right back over to you.
Great, Quinn. Thank you. And thank you for inviting me. It's always an honor and a privilege to be invited to do a speaking engagement. And I appreciate your confidence in me doing this program.
Yeah,
today.
We're happy to have you here.
Thank you. So one of the other things I want to mention on the front, we'll kind of bring this up again throughout the program, is there's also an evaluation sheet. If you have to leave the program early and you want some contact, you might want an initial complimentary consultation, which I won't be explaining really until the end of the meeting. If again, on that web page there, if you kind of just keep scrolling down, you'll see the evaluation sheet. And so if you haven't watched the whole program, you may not evaluate me, but there's a place for you to insert your name and your address. And then if you want the meeting, there's a question down there. Actually, it's right on the front at the top. So if you want a meeting, just check yes there, and then we would be able to do a follow-up. There'll be no follow-up if you don't want any follow-up, so don't worry about that. We're not capturing information for any other purpose other than people that may want to follow up with any questions they might have personally. I'll be going back to that, but you can go and fill that out at any point in time. And again, you can go back and toggle back and forth to the web page to ask any questions along the way. And then I'll just kind of pull them up at the end and we'll answer those questions at that point. So I want to start by asking if any of you have children or you at least know someone that has children. And if you do, well, we're getting the first slide up here. Just a second, there we go. You know that somewhere along the line, parents have to get away from the house and the children, and they might leave behind a babysitter. So the first thing they might do is write down a detailed set of instructions, and then they go out to dinner. What do you suppose is the first thing they do when they get out to dinner? Well, they're probably going to call home. And that's the great thing about being alive, right? If you can always call home. But what kind of instructions would you want to leave behind, if you're going to go away forever? And that's really what we're going to be talking about today. Instructions that you really won't be able to change. So my job as an estate planning attorney is to make sure that you control your own property, giving not only what you want to whom you want, but when and the way you want, and doing this at all at the lowest possible cost. Minimizing what we call living probate, death probate, and death taxes. We're going to refer to these topics time and again. And rather than tell you about the intricacies of all the statutes and the laws that go into estate planning, I'm just going to tell you a story today. And the story is about Bob and Pam. They're married and they have a $2 million estate. So I know your estate's not exactly $2 million. It's either more or it's less. No matter what size the estate is, however, we're going to help you to estimate your probate costs and your taxes. You may be single, widowed, or divorced, and we're going to cover that as well. In our example today, Bob will pass away first. Pam will be the survivor. If you happen to be single, widowed, or divorced, you'll want to pay particular attention to that part of the program. Bob and Pam have some pretty common goals. They want to control everything between the two of them. That's the circular arrows that you see up there. And then when they both pass away, they want to give half to Susan. Susan's the perfect child in the family, and the other half to John, the not so perfect child in the family. And whether your kids are perfect or not perfect or somewhere in between, the chances are whoever your beneficiaries are, including perhaps your pets, they're all going to be different. They're going to have different personalities. It's important that the attorney that's helping you plan your estate understands those differences. And they're only going to understand those differences if you share some stories with them. And so it takes some time. And if you want to share those stories, you need to take time to share those stories with an attorney. We're going to talk about 3 evils of estate planning, or 3 ways to plan, rather. The first is joint tenancy. The second will be a simple will. And lastly, will be creating a living trust. So joint tenancy is a In fact, you really don't have to pay attention to this slide. If you understand, two people own something in joint tenancy, one person passes away, literally whoever lives 1 second longer wins. They get the asset. If you understand that, you basically understand joint tenancy. A will is a little bit different. A will is basically a written set of instructions that direct how your assets are disposed of after you die. So what has to happen before your will can take effect? You have to first die. So in our example, however, today, Bob is alive. Oh, by the way, and then the will can't do anything for you until it goes through the probate process, which we'll get to. So in our example today, Bob is sick. He's laying in a coma. But for 1 second here, we're going to just do a little bit of technical readjusting with our slide presentation with what I'm looking to. It's just a minute here. For those of you Saturday Night Live fans, talk amongst yourselves. I actually watched an old video that last night, actually. Coffee Talk was on. Watch any of the reruns. So a written set of instructions is what a will is. It says where your assets go when you die. So in our example today, however, Bob is sick. He's not expected to die. In a coma. Pam expects, and everybody expects him to recover. They just are not sure when. So Pam's going back and forth to the hospital, and at some point, she decides she wants to sell that house. Maybe they're not going to be able to live there anymore because there's there's stairs in that house. So they had a joint tenancy and a will plan. So who's going to manage Bob's property? Well, the answer is we don't really know, because neither of these documents will do anything to help us. So they're going to be stuck in living probate. That's basically guardianship, where Pam is trying to become Bob's guardian. So it's defined as a lawsuit designed to protect the person who's disabled. And that sounds okay until you really understand it. The primary purpose of probate, however, is to make sure that your creditors are paid. I'm sorry, living probate is to make sure that there's control. So Pam goes to the court to become Bob's guardian. The judge decides, first of all, whether she can be the guardian. And let's say they do. And now she wants to sell the house. So who do you suppose decides what price the house sells for? It's going to be the court. She's got money from the sale of the house. She wants to make investments. Again, the court is going to make those decisions. Then when she goes to spend the money on herself or on Bob, we got somebody mowing the lawn out there. So we're going to go ahead and close that up. Again, she needs to get approval of the court. So what we're typically trying to do here is get that control back with the family. So how long is that going to go on for? Until Bob passes away. Rarely is a guardian removed. So if Bob has passed away, joint tenancy and the will operate very differently, right? Because with joint tenancy, everything went immediately to Pam. But if Bob, like say, planned to pass the house to Pam under his will because he owned it in his own name when he passed away, then the will is going to have to go through death probate. So let's talk a little bit about death probate. It is the legal process of transferring assets to the heirs. And kind of like when I was talking about living probate, it sounds okay until you really understand it. The primary purpose here of death probate is to make sure that creditors are paid off. The first thing that happens when a will goes to the probate court is that a lawyer files a legal notice. And this basically is Bob is dead, and if you think he owes you money, now's the time to come get it. And that ad has to run for 6 months. Finally, when that's over, typically it all takes about a year. That's when we're changing the title of the assets into the names of the beneficiaries. In our simple example today, we're trying to get the house, which was stuck in Bob's name, moved over into Pam's name. We're going to have to resolve any disputes here. You know, Uncle Bob said he was going to leave me something if I didn't get it, and maybe I'll file a claim against the estate. And by the way, if you're in a second marriage, and your intention was to leave your assets to your children of the first marriage, your will cannot necessarily guarantee that, because under Illinois will law, a surviving spouse is entitled to at least a third of the estate if they claim for it, even if they're not mentioned in the will. There's finally an inventory and appraisal made and a distribution of the assets. As you can imagine, there's fees involved: attorneys, appraisals, executors, filing fees. This is kind of like a leaky pipe. The problem is that once you figure out where the leaks are coming from, you might actually kind of have a flood on your hands. So Lawyers get paid two ways to do this around the country. The first is called reasonable compensation, and that's the way lawyers in Illinois get paid. That's whatever the probate judge says is fair. This isn't one of my jokes, but usually when I'm doing this program live, it does have a couple of chuckles. So the other states that don't want to get into what's fair just allocate a percentage of the estate to the lawyers, and then they arbitrarily call that fair. So let's say you own real estate in a county. This is a California example that we're going to give here. And the house really had virtually no equity value. There was a big decline. And so do you suppose this house going through probate would determine attorney's fees based on the $300,000 or a percentage of the $1,000? As you can imagine, it's on the gross value. In this case, the legal fees theoretically would be 12 times the equity value. And I say theoretically because no family who figures out this is what's going to happen would even go after this house anymore. They would just let it sell and go for back taxes or something along those lines. It's also a public record. I don't imagine anyone wants to share all of their financial details of their life with the world. All the court records are public records. In there, you can also find a record of all the bills that are paid. So, you know, what's your mortgage, what's your car payment, what kind of magazines, what's your cable subscription, all those kinds of things. And then you look a little farther and you get the final distribution and a copy of the will. So you know not only what the person had, but who's got it. If we really don't want someone knowing this about us while we're alive, we would want anyone to be able to figure it out after we pass away. An average probate, if you've been through one, it probably took around a year. When we do a live seminar, we poll the audience. It's usually between 1 and 2 years. And then there's probate in every state, as I had mentioned earlier. So we've got it being public. We've got it being multiple probates. And then finally, we've got death taxes. So there's two kinds of taxes, federal and Illinois. The Illinois tax starts at 6.9, goes up to 16%. And it's, go back one, please. And it's applicable only over the first $4 million. So think of it this way. There's actually a tax on the first dollar when you die in Illinois, but there's a coupon that the state gives you that covers the tax all the way up to $4 million. So hold that coupon thought in mind. What do we know about coupons generally? They have a value and they expire at some point. Well, this one basically expires when you do. So keep that in mind. We'll come back to that later. Now, the federal government has a coupon as well, which can be held over. So it's a little bit more valuable by a surviving spouse, and it's $11.58 million. The tax is there, and the coupon don't start until that number, and then the percentage is 40%. There's also another law that you need to be aware of. It's called the unlimited marital deduction, which basically says that all money going to a spouse is tax-free, and it doesn't matter how much it is. Why would that be a trap? Well, let's talk about this a little bit. Let's say that Howard Hughes died with a probate estate, and he was married at the time. And so he left everything to his spouse. What would the tax be? Well, zero, right? Because there's an unlimited marital deduction. But now Mrs. Hughes lives for another 5 years. Well, after 9 months after the first death, what happens to that coupon? It expired. So now when Mrs. Hughes dies 5 years later, does the family have one coupon left or two? Well, the answer is one. And so what I'm going to show you in a bit, if you need it, is how to keep both coupons in place. So we'll go back here. Next one. Great. So this is the federal exemption. And as you can see, it's changed a lot over the years. The last big change was from 2017 to 2018, where we went from 5.4 million to 11.2. With an index, we're now at 11.58. Now, this law by itself will change every year that number based on an index. And in 2026, right after 2025, it will be indexed for inflation back to the year 2012 plus an index. So we're not exactly sure what that number is going to be, but most experts say it'll probably be somewhere around $6 million. But who knows who the president's going to be, who's going to be in Congress, what these laws are going to be. There's no move afoot to change the exemption on the state side, but this federal number does change quite a bit. The $10,000 annual exclusion for gifts that you used to be able to make is $15,000 now. And if you want to use your federal coupon now, you can do it. the $11.58 million. So if you've got an extra $11.58 million and you think you're going to live past 2025 and you want to get that money out while the getting is good, you could do that. By the way, if you've got an extra $11.58 million, my guess is we could find a place at the Animal Care League for some of that money to rest as well. So, and that would be a good tax incentive as well. So I want to caution you though, if your estate's below $4 million, you have federal tax, no. You have Illinois tax, no, but do you have probate? Yeah, you do. Probate occurs, again, not because of the size of the estate. Well, I guess it does a little bit. If you're over 100,000, probate will hit in Illinois. But you're still going to be stuck with living probate and death probate, even if your estate's below $4 million. So the unlimited marital deduction has all money going to the surviving spouse. So we know there's no tax right now. And that's with a joint tenancy or a will. And so Pam's now worth $2 million. And she looks a little bit smiley in this frame. I think she should maybe be frowning. You know, her husband just passed away. But at any rate, now we're going to talk about things growing. Now, generally speaking, a surviving spouse will have more when they pass away than they both had together while they were alive, and that's because estates will grow over time. And so these are just average rates. Now, in any given year, you're not going to see this, but if you go at a 20-year rate, these are the numbers that you're going to see over time. Obviously, we've seen a big decline in the market, but then we saw a big run up since 2017. But again, over time, you're going to see these numbers kind of play out on a 20-year average. I'm just going to use simple math today. If you were able to invest for 10 years and you got a 7% return, money would double. Don't ask me where you can get that kind of return today. I'm just doing easy math for you so we don't have to pull out a calculator today. So now Pam becomes disabled. Who's going to manage her property? Well, joint tenancy is no help because it's gone. And the simple will, we know that a will only helps us through probate when we pass away. So there's no help there. And we're going to need to pick a guardian. Is it going to be Susan or is it going to be John? You know, John actually happened to clean up that day. He's looking good for the judge. My guess is Pam probably would have picked Susan, but again, it's not going to be up to her. Pam dies. And that's when everything goes through probate. So generally speaking, probate does not occur on the death of the first spouse in a married couple situation. It would be on the survivor, or if you're single, widowed, or divorced, it would be upon your death. But generally speaking, for a married couple, it's not going to happen at the first death. But if you did have two probates, on the first death, we had $1 million going through probate at 4%. That's the average. That's $40,000. Then the estate grew, it doubled. And so then there was another probate at 4%. That's $80,000, $120,000 as the worst case scenario. Let's try the best case scenario. So let's say that what if we could subtract Bob's probate? And how would you do that? Remember, I told you there's often no probate at the first death. So we're going to take the $40,000 out. And then instead of having Pam's probate done at a full 4%, we're going to do it at 2%. So now we're down basically at $80,000. Taxes are due 9 months after the date of death. By the way, most of my clients don't have taxes. So what I talked about with regards to the tax-free levels, understand that I would say 25% maybe of my clientele have a tax problem. The other don't. They're coming primarily to cover the probate issues. So let's do a summary of what we talked about so far. Avoiding living probate. Well, with joint tenancy and the simple will, there's nothing helping it while you're alive. So there's no help avoiding living probate with either of those. Avoiding death probate. Well, that's the one bright spot of joint tenancy, right? Because everything goes to the survivor at the first death. But with a will, that's not going to happen. And then on the second death, joint tenancy is no longer any help because there's no more joint tenancy. And the will, we know by now the word will should equal in your mind the word probate. If will and probate mean the same thing to you at this point, you basically got the first part of the presentation. Taxes, federal taxes, you can't avoid them with joint tenancy or the will because everything goes to the survivor. That's our Howard Hughes example. And when we do it that way, we know that we're going to lose one of those coupons. So other problems of joint tenancy have to do with gifts, for instance. When you give someone something, for instance, like a house, about, I would say, every year or two, I have a surviving widow come to me and I look at the real estate deed and a child's name has been put on there after the first spouse passes away. Well, when you put someone's name on your deed, you've actually gifted them a half of the value. And what did I say you could leave as far as a gift without having to pay gift taxes? $15,000. So unless you live in a $30,000 house, adding your child to the deed is probably not a good idea. It could also create capital gain issues later on that could have been avoided. Passing property to an unintended heir. This is how this might happen. Husband and wife are married. Husband leaves assets to the spouse. Everything seems fine. Have you ever seen the surviving spouse get remarried? Okay. Now they die before the second spouse. They have children from the first marriage. Who's going to get the assets? The children from the first marriage or the second spouse? We don't really know. And if it's the second spouse, that could be the unintended heir. My guess is you probably don't have to look too far in your family tree where someone got assets they weren't supposed to get just because of joint tenancy. This is probably the biggest fault that people will have with regards to joint tenancy as a planning tool. Advantages, creditors. You put someone on your checking account because you want them to be able to pay bills for you. Their creditors come along with onto your checking account. There's no control with a joint tenancy. You'd never put money in a joint account with an 8-year-old because if you die at 18, that child can get access to the money. And at 18, the first thing that kid is going to do is call a financial advisor and create a college savings plan, right? Probably not. What does a 18-year-old believe a good investment to be? It probably looks something like this. Maybe it's a motorcycle, whatever, but it's probably not a college savings fund. I want to show you only one example of a trust. And the reason I'm telling you this is I'm not telling you right now that you should have a trust. The only way you'll know what the right planning tools are for you is to sit with an attorney that you know that you get to know that you trust that will give you specific legal advice for your specific situation. I'm going to say things today with regards to trust that don't apply to you at all, some that apply, and some things you'll need in a plan for yourself that I don't cover at all because I don't know you. So getting back to our presentation here. So what you need to be on the lookout for is what I call the boilerplate of the one-size-fits-all trust. As you're determining what firm you want to use, make sure that you don't wind up with a firm that's going to give you a one-size-fits-all plan. These are typically 10 to 12-page documents. They all look about the same. I rewrite one of these just about every month. How would you avoid this, right, before you've got it? Well, I can't tell you for sure, but I can tell you the most common denominators. When I see a boilerplate plan, I will ask a client, not what did they pay, but when did they know what it was going to cost? And almost always they tell me it was like one price for all, or they found out prior to a consultation. And I want you to think for a moment, if a lawyer can quote you a specific fee before they know you and your situation, how likely is it that they're doing something unique for your situation? My experience is that's not all that likely. The other problem is those are typically lawyers done at the lowest price point. And when you go to the lowest price point, typically service goes away. And what you're doing when you hire an attorney is hiring someone for legal services, not in document preparation. And one of the major services that you need is what we call funding assistance. That means making sure that what you own is in your trust name. Now, it's not that hard to do. My experience is, though, that if a law firm is not there to help you do that, it oftentimes doesn't get done. So someone will come with me with a trust, but nothing is in the trust name. What that means is that family would have actually been in probate. I call that probate in disguise, because nothing was actually in the trust when the person passed away. I think there's obvious reasons why you probably don't want a general practitioner handling this kind of affair for you. It's a unique situation. Make sure that you have something uniquely crafted for you. A problem with probate is a problem of ownership. Jointly owned or individually owned property are going to be probatable either on the first or the second death. Is there a better way to control property? And the answer is yes, for most people. And that's going to be as a trust. Now, you're going to see this slide about a dozen times, and each time it comes up, I'll explain some of the circles, I'll add some arrows and some numbers at some point in time. But once you create a trust, you need to change the name on your accounts, and that's called funding the trust. And again, we're there to help you get that done. We give an unlimited amount of funding assistance included in our services. And we can actually fund the trust for you if you want us to do certain of those functions as well. But and again, your trust will be your name followed by the words living trust, and that now needs to be integrated properly either on beneficiary designations or titling on assets that you have. Everyone is a little different, so I can't give specific instructions on how to title specific things because the type of plan that you create oftentimes renders the instructions different from one to the next. So you got to change the name on all of your accounts to the name of your trust. Now, we're setting up babysitting instructions here, right? So the first example here is going to be for a husband and wife, married couple with a taxable estate. I will go over a non-taxable estate as well, but we're going to cover this. Now, what do the babysitting instructions say? Well, take care of me, take care of my spouse. But let me stop for a moment. Do you think every trust I've written for married couples take care of my spouse? No, because you could be in a second marriage where you're taking care of yourselves, not each other. Take care of my dependents. Do we all have dependents? Well, not necessarily. And some of us have different types of dependents. Maybe you're taking care of a child and a parent, for instance. Let my trustees be my spouse. We're saying a spouse down there, but who else do you suppose you might see as trustees? Maybe a child, maybe a CPA, maybe a bank. What's the proper choice for trustee? Again, we need to go back to the simple example. These are babysitting instructions. If we're going next door to meet with the neighbors for an hour, you can get a teenager to watch your kid. But if we're going on a 2-week vacation, we don't really have the right babysitter, right? So picking all of these decisions, and I'm not going to go through this on every slide, but on 3 points here I'm mentioning, there's probably no one way to do it that would fit everyone. I'm just trying to make the point here that the boilerplate trust is really not something that's that attractive because you can't make one size fits all. And what about when only one spouse is alive? You're going to notice now husband's trust is in green. He passed away. Wife's is in yellow. That means she's still alive. And maybe we set up money in a family or a marital trust. For who? Probably in our example, the spouse, dependents if you've got them. We'd certainly want to minimize taxes, and maybe we'd use a spouse as a trustee, but you know you'd have a lot of choices there. And then after both deaths, neither spouse is alive, you see these yellow circles highlighting now. The common trust, for instance, might be so a trust that's embedded in the original trust, but it's not funded. It doesn't become active until both spouses have passed away. So a common trust might be there to take care of a lot of kids together from one pot. But then you might say, Ted, my kids are older. So the yellow circle that says children might be a separate trust for each child. So why would we create a trust for each child? Well, maybe we wanted to make sure that they were protected in case there was a divorce, or we wanted money one day to pass to our grandchildren. Or you could actually set up a trust just for the grandchildren. Perhaps you're afraid that they wouldn't have money to go to college because maybe the children are struggling to make enough money to make that a reality for your grandchildren. Charity, here's where you would have the Animal Care League, perhaps for a lump sum, or perhaps a trust of its own that paid out an annuity over time that kind of matched the gifts that you've been making year over year. Or you want it to be earmarked for a certain structural change, or to, there's really no limit to how you can characterize how you want your charitable contributions to be made, which, by the way, would be a deduction to the estate. If you need that as a deduction, that would be good as well. You can also use beneficiary designations to do that. If we're in a meeting, we might look at the tax advantages of using a beneficiary designation on an IRA or a 401k to get money to go to the Animal Care League or your other favorite charities. Others could be nieces, nephews, maybe a godchild. This is where you would also have perhaps a pet trust. We are probably the leading source of pet trusts in the state of Illinois. I don't know that for certain, but we do a lot of these presentations at various shows where people are there with their various pets. And so it tends to be that we do a fair amount of trust for that purpose, to take care of our other family members, our furry friends. Now, if you're single, a widowed or divorced, or you're married, and you just have an estate that you never think is going to be taxable, you can do one trust. And that's something we're going to recommend if you're a candidate for that, because it's going to bring the cost of the planning down. So if we can do one trust for 2 people, that's going to be a better solution. But again, it's going to be dependent to some degree on taxes. Babysitting instructions: take care of me, take care of my dependents. Let my children sign for me. If you're single, perhaps children isn't a choice for you, so then maybe it's going to be a brother or a sister or a trusted advisor of some sort. So now we're going right to the after death for the single person or joint trust. We might be going right to those contingent beneficiaries, if you will. The group of children in the common trust or individual trust for a child or a grandchild. Again, Animal Care League or your favorite charity or others. Trustees, again, would be the people that would sign for you. The bottom line is that if you choose the people that can sign your name, then the court doesn't get involved in that decision. Now, a trust has three positions. The trust maker, that's you. The trustees are your babysitters. And then there's the beneficiaries. Those are the ones that get to spend the money. Now, if you could just be one of the three, do you have a favorite? Probably you're going to say beneficiary. What we're going to do now is give Bob and Pam a second chance. We're going to reset the program and we're going to play it again forward. Only this time they came to a meeting. Our first meeting in the firm takes 3 hours. At the end of the consultation, which was complimentary, they had decided they wanted to have a trust. That trust was going to have them both as trust makers and co-trustees, because remember, they wanted to control everything between the two of them. And like all of us, they want to be beneficiaries, which means they want to be able to spend their money however they want, whenever they want. So occupying all three positions, it looks like they control everything, doesn't it? And that's because they do. They have total control over their property. There's no new taxes. They'll file the same tax returns using their own social security numbers. And since these are revocable, you can change them whenever you wish. Remember our example. Bob got sick. What did Pam want to do? Sell the house. Let's go to the trust example now. Bob is in yellow. He's the one that's sick. Who's the trustee? Probably Pam. Can Pam sell the house now if the house is titled in the trust without going to court? Yes, all without attorneys. No one's going to court, no guardians. Can she take care of Bob with the money? Yes. Can she take care of herself as a beneficiary? Bob would likely have named her as a beneficiary of his trust so she could take care of herself. Sell the house, invest the proceeds, spend the money on her, spend the money on Bob. Again, they want complete control that way. Bob dies. Does his trust avoid death probate? Well, the answer to that question is everything titled in the trust? So if everything's in the trust name, Bob's green circle now is pointing an arrow down to the family trust. Everything would immediately be in the family trust. And the family would include, in this case, Pam and the children if they wanted them to be current beneficiaries. If you had younger children, they would be current beneficiaries. If they're older, they're probably not going to be beneficiaries of the family trust until the survivor dies. But all this is going to happen without attorneys going to court, no executors, no time delay, no public record. By the way, this is a private agreement. It doesn't get filed with any governmental agency. And the time is whatever time the trustee decides they want to get things moving. There's also no probate in any other states. As long as we take that out-of-state real estate and get a deed written to put it in the Illinois trust, you're not going to have probate out of state either. We are part of a wealth council network. We have colleagues all over the country. No matter where you own a parcel of real estate, we can get assets transferred to the trust. And what about estate taxes? Well, there's no tax when Bob dies, and there better not be, because in our first example, the taxes only hit on the second death, right? So no taxes at the first death, and either federal or state. And now Pam became disabled, and so now we're back up on the top. Pam's trust is highlighted, and who's the trustee now? She undoubtedly would have picked Susan. She was the perfect child. Without attorneys going into court, she can take care of mom, not become the guardian formally because she's already taken position as trustee. She can take care of mom and any other beneficiaries. So who else might be a beneficiary at this point? Perhaps Pam made grandma a beneficiary, because she always supported grandma and her rent. She always had trouble making rent. Pam sent $100 a month to the landlord. Could Susan, now as trustee for Pam, while she's disabled, give that $100 a month to grandma's landlord? And she could. Would the judge have allowed that in our first example? And the answer is no, because that payment from Pam to grandma, or from the trust of Pam to grandma, would not have been seen to benefit Pam. But Pam could state that in her trust, and grandma would be safe with rent being paid. Does Pam's trust avoid death probate? Obviously, the answer to the question is everything in the trust? If we funded everything properly, then everything should now be moving into those yellow circles on the bottom. There's no new work being done at that point in time. These trusts have already been created according to the trust maker's instructions. They're just being funded. Think of them as a bucket. If you think of the trust as a bucket, funding the trust is filling up the bucket, right? So that when you kick the bucket, there's actually something in the bucket for the trustee to handle. That actually was one of my jokes, so I hope you got a kick out of that. I don't have a laugh track in the back to help me out. So, so again, all this is happening without attorneys going into court. There's no executor's fees, probate, public record, or probate in any other states. And what about the taxes? Well, by using the two-trust strategy, we're going to double the exemptions. So the federal exemption, which was 11.58, is now 23.116, and the coupon for Illinois, which is 4 million, has now doubled up to 8 by using the two-trust strategy. Again, if you've got an estate under 4 million, we're going to use the single trust strategy, and that's the majority of the couples that I have seeing me these days. But here's how it happened. If you needed the tax planning, you'll see Bob's circle, and you're going to see an arrow coming out of there with $4 million. So when Bob dies, as that arrow shoots the money down to the family trust, that $4 million coupon is going to be used. So we're not going to let 9 months go by to have that coupon expire. That 4 million is now in that family trust, and it's staying there until Pam passes away. So now we're up on Pam's trust. She still has a $4 million coupon. When she dies, we're going to follow that arrow from her all the way down, and there's your next $4 million. So down below at the bottom here, you'll notice we've got a full $8 million going however we want. Common trust, children, grandchildren, Animal Care League, other charities, nieces, nephews, brothers, sisters, parents, wherever you want that money to go. Now, a trust will typically go on in our firm to create benefits for loved ones. A boilerplate plan, by the way, by definition, ends when the trust makers pass away. Virtually none, I wouldn't say none, but virtually none of the trusts that we create end when our clients pass away. Most of them continue for some reason. And I think when I explain this, you'll understand why that's the case. The first is to benefit minors, right? You can't give money, a lot of money that would vest in someone's estate when they're 18, right? We want to hold it in that common trust. We talked about that. When they grow up, maybe we'll stagger the distribution, but we want to hold it together for sure. And if we've got that, those minors, we don't want them to be blowing that money early. They might need it later on, by the way, because I mean, they've lost their parents. They need some help with this money. Protecting money from divorcing in-laws. So you can leave money in a trust. Let's say that you died with a boilerplate trust and you left money in for your daughter. And then years after you passed away, your daughter got divorced. Well, who's likely going to take part of that inheritance that was received when you passed away? Well, it's all been probably mixed up with your daughter and son-in-law, so he's probably going to walk with a part of it. You want to protect that? We create a trust for your daughter. And we say that she's the beneficiary, so as long as she's with him, he can benefit. But if he leaves, he doesn't take any of that trust with him. You might say, Ted, I'm not worried about that. You know, my kids are all happily married and they're going to stay married. I'd say, well, that's great. Why would we want to leave that a trust for that situation? Let's say you left money to your son. Now, generally speaking, in a married relationship, a husband would pass before a wife, a male before a female, a younger before an older, and your child is either younger or the older or the male, and they pass away. So they leave money to their surviving spouse. And what if that surviving spouse gets remarried, right? We've already talked about that situation. We now have money going in a situation that we're not interested in. Special needs. If you have a child or a beneficiary that's got special needs and they're getting state aid, in certain circumstances, if they receive an inheritance from you, their aid is cut off. But you may decide that's really not what you want to do. So you create a special needs trust that can provide some extra benefits to them, but not so much as to wipe out their benefits. Protecting a spender, maybe trying to help them from hurting themselves. You know, I have a client who set up a trust for a child that doesn't start to pay out till 65. And the reason for that is the child will never have a retirement plan, and the parents want this to pay out for the next 20 years after the age of 65. Protecting estates from creditors of your children. So if you've got a child in a high-risk profession, doctors, lawyers, architects, to name a few. These are professions where you cannot avoid personal liability. So if you leave money to your physician daughter and she gets sued for professional liability, and she may lose the inheritance that she received as well. If you put it in a trust, you can protect it from the creditors that might come after her. They can take everything she's got, but they can't touch the inheritance. Maybe you've got a successful child. They're making a lot of money and they don't really need what you're going to give them. Now, I didn't say they're not going to want it. I just said they're not going to need it. And a child who gets money that they don't need, in my opinion, can only do two things with it. And that's save it or spend it. So this is a successful child. So we're going to assume that they save it. So now their estate was here and you died. Did their estate go up or down? Well, it went up. and now they live for another 30 years. That's about how long kids live past the death of their parents. Did their estate go up or down? Probably up. Now, your estate is in there somewhere, right? That piece, right? Part of that is your estate. And if they die with a taxable estate, your money is part of it. You might actually lose part of your estate on your children passing it to your grandchildren by leaving it to your kids the wrong way. Yet if you leave it in a trust for your child, instead of that money raising in their estate, it sits over here on the side. And it can grow or shrink based on your child's need for it. But whatever it is can get paid forward to the grandchildren with zero death tax. So this is called dynasty or legacy planning. If this is something that's important to you because you have a child who's going to be successful, or you think you're going to leave them a lot of money, or together they're going to have a taxable estate, it's something that you need to look at. So what if your trust survived you for 100 years? Okay, well, or what if your ancestors created a trust for you 100 years ago? You might say, let's go back one. You might say, Ted, it doesn't matter. No one in my estate, no one in my ancestral line. Oops, the other way. It's back to one more back. There we go. So no one in my family ever left me anything. And I would say, well, that's perhaps true, but not accurate. Let me tell you what I mean by that. I'm the first one in my family to graduate college, let alone law school. And it's not because anybody died and left a lot of money. It's because everyone tried to make it better for the next generation. They made sacrifices. We stand on the shoulders of the ancestors that went before us. And so your story's probably not much different than mine. Most of my clients never really inherited much wealth, but they did inherit an opportunity. And what did they make of that opportunity? So if that story kind of resonates with you, I think we would probably be a good fit, because getting into the people side of things, the family side of things, and what's important and what's important to you. If your family is your pets, then how are we caring for those pets upon your demise, or if you get sick? Now we can go past this. So I want to talk about just a couple of other issues, and then we're going to get into the evaluation form, and if you want a consultation. So Illinois Trust Code got enacted this year. It's probably not going to mean a whole lot to many of you, but basically beneficiaries have more rights to get information from trustees. They have to give more accountings, and they have a duty of loyalty that's been built. Then there's the Security Act, which actually probably will affect most of you, and it did two major things that I want to touch on. The first is the required minimum distribution date is now 72 years of age, not 70 and a half. So you've got an extra year and a half before you have to take money from that account. Now, the downside is when you pass away and you leave that money to your heirs, they used to be able to stretch it over their remaining life expectancy, paying taxes over a longer period of time. That period of time has been shortened now. They have to pay all the taxes within 10 years. There's no more lifetime stretch. If you want to meet with me, and we're not necessarily the right firm for everyone, so I want to set your expectation. If you think you want to come to see me, our meeting does take 3 hours. If you're married, we do ask that your spouse be there, or whoever your significant other is that's going to be planning for you. We'll review your current plan if you've got one. If you've got probate issues, we'll go over that. Estimate your taxes if you've got those. More importantly, listen to you, understand what you want, and design instructions with options to meet those goals. Generally speaking, someone doesn't leave my office without having 2 or 3 or 4 strategies or options that will range in level of sophistication and price point. So typically we can find something that fits clients, because it's not, like I said, a one-size-fits-all plan. We're going to have several different options. Hopefully we've gotten all of your questions answered at that time if we don't get them taken care of today. So now I'm going to take you to the evaluation sheet. And so if you'll toggle back to your evaluation, or to the website page where you first got to us, to click on this, you're going to see an evaluation form. So this is kind of where you started. And then if you sent any questions, you sent them in right here. And if you just kind of keep going down there, you're going to see the evaluation form. So if you don't do anything else today, if you could please put a rating in there, that would be great. The ratings are nice. Oh, Tim gave me a 9, a 1. Holy cow. At any rate, you're going to want to type some comments in there. If I'm a 1, tell me why we were a 1. Maybe we had a bunch of technical difficulties and I can throw my partner under the bus here. Maybe I spoke badly and you want to say something that I could have done better. But basically, I've done hundreds and hundreds of these presentations, and it's been honed basically by the comments that I've gotten from people who have participated over the year. I read every one of the comments, and some of them have basically gotten me to where we're at today. You know, you have a program today that was cultivated and honed by all the people that have watched it before you. More importantly, or just as importantly, down below it says, I'd like a no obligation meeting with Ted regarding my plan. So if you click yes there, what's going to happen is you're going to see a drop-down menu that says how you want your meeting. You want it in person, virtual. Most people are picking virtual now. We're probably going to be virtual for the reasonably foreseeable future. We can, by the way, also deliver virtually. You don't have to leave your home. You don't have to be exposed to anyone else if you don't want to. We'll sort of see how this develops over time. But right now, we're practicing very safe measures. So if you want to be virtual, we can take care of that. What's the best time to contact you? Typically, we try to do this via a person calling you to set your appointment. Is it better to have Michelle, my scheduler, call you in the morning or the afternoon? If you prefer an email, you can also put in the comment down below that you prefer to be contacted via email. She can send you things out. The only thing I'll caution you there is, please don't think that just because she sent you email availabilities that they're going to be available 3 days later when you respond, right? So if you want to get it, you know, right away, you want to respond very quickly. That's why I prefer to actually do them on the phone. That way there's not a mix up with us, you know, thinking you got an appointment that you didn't get that you didn't actually get. So you'll get confirmation letters, by the way, and you get a packet of information from our office and an information checklist, which you can either find on our website. So on this very page, if you wanted to, you could go up into the form section and you could click on that, and it's the information checklist. I'm not going to take you there now, but you're going to see a little forms item. You can go there, click on it. You're looking for the information checklist if you want to get a head start on that. What time of the day would you typically like your meeting? So these are 9, 12, and 3 are the typical start times. That allows me to do up to 3 meetings a day. I actually only ever take 2. My bandwidth, really, to do someone justice, I need to have some downtime in between paperwork for the clients that I have been working on. So then below there, you're going to want to give us your contact information. So we're going to need your name and address. And if you want to go ahead and see where that gets filled in, Tim could go ahead and show you where that goes. So Tim would be filling in saying, I've got me. And so that's all right. You guys can do it in. If you're typing it in, you just type in your name there. And that's okay. I guess we're not seeing it, but everybody knows what you're doing. Same thing with the drop-down menu here. And then you're going to want to give us your phone number. So we'll give you just a moment to fill that in as well. And then your email address. And so we'll give you a chance to fill that in as well. If you've got any kind of plan at all and you want to tell us what that is, it'll give us a feel for sort of what the meeting is going to look like, because maybe you've already got a trust, then we know that you're doing a review. Maybe you've got a land trust already. Maybe you've got some powers of attorney. Maybe you've got a will in place. Maybe you've got nothing. By the way, don't be embarrassed by that. Most people come in with nothing. So no problem there. Or they come in with a very old will, typically one that was created, if they've got descendants, typically created when, when the kids were, like really young. Also, I do the only type of marketing, so to speak, that I do is education. So if this presentation you thought was valuable and you have a group and you think this presentation would be good for that group, make sure that you give us that. The other thing I want to mention is the way we got connected with the Animal Care League is we give a portion of our fees to charity with every new case. In this particular case, we allowed our clients to decide that they wanted to give money to the Animal Care League. And so we made sure that that happened. And so that's when I met Quinn, and kind of everything went from there. So if you'd like us to do a seminar, just check the box yes. I'm not sure if we check yes, if we actually ask you for the name, probably that would generate just a phone call from me. and find out what your organization is. And if you've got a friend or a relative, they didn't get a chance to watch today's program, they're not going to come out to a live program, they want some information, happy to do that as well. You'll also get a call from me once you get your information packet, just to kind of get to know each other a little bit, see where you're going, and talk a little bit about fees. Fees range pretty dramatically along the board based on the level of sophistication. So, we have people that do will planning, they might spend under $1,000. Trust planning usually goes between 3 and 10. Average client usually spends between 3 and 6. Every client has price points along the spectrum. So we never have someone leaving our office with one strategy and one price point. So we've got usually something that can fit anyone, no matter what their circumstances are based on the level of sophistication and the level of cost. So we can go either way there. So I believe Quinn is waiting by. So we're going to kind of grab her back up and see if I forgot anything or there's anything else that she wanted to mention. So we're going to invite Quinn back into the meeting. And there she is.
Hello.
How you doing, Quinn? How do we do?
Good. I'm going to mute the live stream so that I'm not hearing two things.
Yeah, right. Otherwise, we're in a feedback loop there.
Yes, exactly. Well, thank you so much for all of that. That was amazing. Great information.
My pleasure. My pleasure.
Thank you, everyone.
That maybe I get a chance to introduce Sherman too before we go. So why don't we just chat, and I'll look and see what questions we've got here.
Yeah, absolutely.
Well, it looks like we got people that came in, but one. How much commitment or expertise does it take to be a trustee? So that's a great question. And again, it depends on if we go back to the babysitting instruction, what's the trustee doing? So the more sophisticated the job, the more sophisticated the trustee needs to be. I will tell you, generally speaking, people will use children or close friends or relatives in this capacity, backed up with a professional, which might be their CPA. It could be a law firm. However, my firm doesn't usually take that position. I feel there are better professional trustees that do that, where they will work in conjunction with us. So if you want us to stay on as the lawyer, but you don't have a person as a trustee, we've got suggestions we can make in the corporate world for an independent trustee. So someone who's generally speaking, though, pretty detail oriented, someone that can do follow-up. They're good at kind of putting together a checklist. There you're going to see my son-in-law, Tim, and Sherman. And so let's see, what else would be characteristics that you would be looking for. They could also, by the way, be a beneficiary. So oftentimes when we create a trust for a child and we trust that child, once they take over their own trust, maybe the administration is done. So someone else did the administration, maybe they got the house sold, they got the bills paid, but now we got money set aside in a trust for a child. We might make that child their own trustee. So they determine what they get, when they get it. But it's still in a trust because maybe the parents wanted that money set aside to protect them in case of a divorce, and maybe wanted the money to go to the grandchildren one day. So great question. So thank you for that. And that question came in from Miracle Jones. Thank you. Hope you don't mind that I called you out there. I don't know whether I'm supposed to do that when I'm doing this or not. Let's see. And it looks like that really is the only question that I've got today. Did you get any on your end, Quinn?
None came through, but I did want to confirm. I think somebody mentioned, is this video of this particular stream going to stay out for a couple of days? Is that correct?
We can leave it up. I've got to check just what's in there because there was a lot of pre-production stuff once we went up to do rehearsal stuff. I just want to take a look and see what's going on there. Yeah, I don't know whether we can trim it or edit it or what it is.
Okay. Just wanted to confirm that.
Yeah, we will eventually have the ability to do this. I actually produced, and this is a really good question, and that is, I'm one edit away from a polished version of this that was made for TV.
Okay.
So once we have that available, we'll be able to give someone a private invitation to come and see that. And there's a little bit to do with regards to the fact that it's legal content and that we need to know who's seeing it. Whereas this right now, we really don't have that. This is kind of our first entrance into this, and we trust all of your folks, so we're not worried about who's seeing, who may not be telling us who they are. But generally speaking, going forward, you would have the ability to get to it, but we would have to send you a private invitation to view it.
Got it. Okay, understood.
Anything else?
That was the only logistical question I had.
So meetings, by the way, are held in any number of offices, assuming that we're back in offices at some point in time. Regis is the office sharing arrangement that we have, and they have 24 offices around Chicago. If you look at our website, you're going to see a dozen of them that we use regularly, and we can schedule you in any one of those meeting spots. I have an assistant that gets me to those meeting spots, so I can be convenient to you face to face. If that, and that's where we will be at some point in time. Exactly when remains to be seen. And right now, I think everyone, myself included, I've got a mother who's will be on stage 7 of 8 stages of chemotherapy. So I'm being a little extra careful in that regard. So that's just allergies, by the way. I'm being a little extra careful. So yeah, I would prefer, at least on the front end, to do these meetings virtually. Danielle, my assistant attorney who came on with us in 2016, she's doing all of our signings, and our governor gave us a statute which allows us to do remote witnessing and notarization. That was going to be the sticking point, but we've got another 30 days from the end of the stay-at-home order, assuming that it ends here. The ability to do document executions without leaving your home will remain for at least 30 days. I'm guessing there'll probably be some lobbying to keep that going further, because especially in the estate planning world, many of the clients that we deal with are people in the at-risk population. I'd like to think that people do this in their 30s or 40s, but from a practical standpoint, it's usually 10 years plus or minus retirement. So those would be people that we want to maybe be a little safer, a little bit longer. So hopefully they give us this statute, which allows us to perform in a fashion that keeps them safer. We'll obviously make the safest arrangements we can when they come into our offices. I was actually looking today or yesterday at some of these screens that we might be able to put up. Maybe we'll put 2 desks between each other, get at least 6 feet apart, and maybe have one of these fiberglass or plexiglass screens between us. So yeah, I had to go to a doctor's appointment yesterday, and I was 6 feet back, and then there was still plexiglass there. So we're respectful of this, and we want to be respectful and make sure that.
Yeah, thank you so much. We're very appreciative of you making these accommodations for us during social distancing and all of that, because I know we had planned to do this in person, but things change. So.
Well, I want to thank you for your progressive attitude in terms of kind of keeping the ball rolling, because we had 5 programs scheduled that are off. And about the time this came into play is when people start to schedule. So we already had 5 in the hopper, and that's when people are like, yeah, let's do this before summer comes. And so this is seminar season for us, and you're the only one we're doing. So I want to say I thank you for allowing us to keep the pipeline fed. In case you haven't figured it out, estate planning is an occupation that helps more and more people, not the same people more and more. So opportunities like this to be able to speak and do education allows us to fill the pipeline, which allows us to have clients, a month and 2 months and 3 months and 6 months from now. We realize everyone's not going to come in right away. They might take a year or 2 to come in, but they're in the pipeline. And so right now we're just kind of working off of older files that were in the pipeline for a while. But thank you for this opportunity, and hopefully it works out well for the Animal Care League. That we know that there'll be donations coming back through the Give Back program with the work that we'll do. More importantly, we're looking to help foster the future because it's the planned gifts, the larger gifts that provide kind of permanency. So you're not kind of having to worry, month after month, how are the bills going to get paid and how are the animals going to be taken care of? So thank you.
Exactly. Yeah. Thank you everyone for joining us. I'll send out a quick follow-up email that has a link to the evaluation form to make sure you take a few minutes to fill that out. And I'll also, go ahead.
Go ahead.
I'll also link to the page on Animal Care League's website that's just a little bit more about planned giving as it relates specifically to Animal Care League, if anybody wants to take a look at that as well.
So this is actually what a portfolio looks like when it's done, when a client gets one, if you're still watching these days. So these are all the different documents that go into a typical estate planning portfolio. All of those are things that we would go over, and every fee that we quote includes all of those documents. I also give away books. I think I might have given one away to Quinn. These days I'm giving one away called Rediscover the Saints. If you're online there and you want to send a note, even though you might not be particularly interested in seeing me right away, but you'd like the book, I'm happy to send that out to you. So just let us know. I can actually send you a list of the books that I have that we give away if you're interested. Kind of my thing.
All right. Thank you so much.
All right. Peace be with you.